Hi, I'm Jeff Rehmeyer. I'm a business attorney here at the CJ Law Firm. I've been with the firm for nearly 20 years. As part of my business work, I often assist clients with matters involving intellectual property. By intellectual property, I mean trademarks, copyrights, or patents. A trademark is a name, word, or symbol that can be used to embody the goodwill associated with a product or a service. Typically, marks that involved products are considered to be trademarks. Marks that involve services are considered to be service marks. I'll offer some examples of trademarks to better explain. In York, Pennsylvania, Harley-Davidson is very well known. Harley-Davidson has a strong brand name that's typically associated with its motorcycles. However, because of the strength of that trademark, it's also used elsewhere. As an example, you can commonly see Harley-Davidson on t-shirts or other apparel. Another example I would offer is the Pennsylvania State University. Penn State is first and foremost an educational institution, but because of the strength of the mark, and in particular the lion head mark, you can see it elsewhere. It's commonly seen on hats, shirts, bumper stickers, or magnets for cars. Applications for trademarks are typically based upon existing use in commerce or an intent to use the mark in commerce. If the mark is already being used, then that can be the basis for the filing. If a company intends to use the mark but would like to secure its rights before beginning that use, the intent to use application can be filed. Once the application is filed with the United States Patent and Trademark Office, an examining attorney will be assigned to review it. That attorney will review the proposed mark to determine if he or she believes it might cause confusion with existing marks or marks that might be registered in the near future. The examining attorney can also raise any other questions or concerns that he or she might have with the application. After those issues are addressed, the mark would proceed to publication in the official gazette. At that time, other holders of marks have the ability to object to the mark if they have concerns. If no objections are raised, then the mark would proceed with registration, which would occur shortly thereafter. When using a mark in commerce, one should utilize symbols to claim the ownership rights. If it's a trademark, the TM can be used as a designation. If the mark is a service mark, then the SM can be used. After a trademark is registered with the United States Patent and Trademark Office, the capital R with the circle can be used with the mark to designate the ownership rights and registration of the mark. At that point, the owner of the mark has substantial protections in case anybody else would try to use that mark without authorization. Such a use would be considered trademark infringement. Under federal law, the registrant of a trademark has powerful rights and remedies to deal with an infringer. If you have questions with regard to trademarks, whether it be registration, infringement, or other issues, you may look on our website for additional information or contact us and we can talk to you.